and commissioners of all the states who are heading the Ministry of Consumer Affairs, NGOs, students, and the state commission members, presidents. So all those people invited in 2011 to discuss on misleading advertisement. And around 4 regional conferences throughout India conducted. And at the end, we found that there is a need for regulatory authority to control these types of misleading advertisement. That was decided in 2011 itself. For this program, from the Ministry of Consumer Affairs, Government of India, Pankaj Agarwal, Additional Secretary, which I'm showing cursor, he was a former, then Additional Secretary, Ministry of Consumer Affairs, and he inaugurated this program, and we discussed a lot on that day. And also after that particular program, especially in National School, students did a empirical research on misleading advertisement, and they purchased cosmetics. They applied on themselves, depending on whatever tall claims cosmetics have made, but ultimately all tall claims found false. Then students sent a legal notice to the all MNC cosmetic companies, and later filed consumer complaints also before the district commission and state commissions. So these are the background. Since 2011, Ministry of Consumer Affairs working on the misleading advertisement, and now ultimately it is implemented today. So just I wanted to share this information before starting the presentation from Anita. Anita, over to you now.
Good evening to one and all. Hope I'm audible to all.
Yes.
Akshay, am I audible? Yeah.
Yes.
Okay. Good evening to one and all. Firstly, at the outset, I would like to thank Professor Ashok Patil for the great opportunity for me to be a part of this webinar series. Thank you, sir. Regarding today's topic, I think, the participants who have gathered here, I think you all are aware of already the 3 chapters which have been exclusively included in the new act, that is Consumer Protection Act 2019. So today, I'll be mainly discussing a little bit briefly on misleading advertisements, which are mainly not as an exclusive chapter, but a small portion of the provisions which are incorporated in the act. I'll be discussing on that. So just kindly allow me to share my screen. Hope my screen is visible, Akshay.
Yeah, ma'am, it's visible.
Okay. Yeah. To start with, as you all know that misleading advertisement is being, mainly was not there initially per se in the earlier act, that is 1986, but under this act, it has been, mainly focused on with regard to unfair trade practice. So to tell you about the topic in my brief next 30 minutes, I want to mainly take you through the slides where I want to mainly tell you how the term misleading advertisements has really brought into the importance in today's scenario. Coming to various misleading advertisements which you all might have seen, whether it's cosmetics, whether it's any health drink, or whether it might be any advertisements which regard to any of your snacks, we all know as a common man that misleading advertisements are somewhat which we don't believe in. But the problem arises as to we don't feel that it is a problematic. We see, okay, such and such creams comes, that less wrinkles in 1 minute. We know that it's not true, but the problem arises that we don't raise a voice as to why is such advertisements misleading the consumers, that in fact will encourage the traders or the advertisers to come with such misleading advertising. Now let me put a disclaimer initially that competition in the market, especially in the market where the industry of advertisements is increasing at a larger extent, and the advertisements is the only means, or you can say the only medium for them to attract the consumers through the advertisements. There's no doubt about it. But the problem becomes, and the problem arises when they adopt or they try to make such misleading tactics, which is not a healthy competition. If it's a healthy competition, when if the advertisements are true, if they are correct, if they are genuine, yes, the advertisements can be promoted, that can be encouraged. But problem only arises when misleading tactics are used. Now let me take you to something different aspect as to not only economically but also misleading advertisements adversely affect a person sociologically, psychologically, and economically also, because initially you did not want to buy any product, whether it may be a cosmetic, whether it might be your any of the brands which might be endorsed by your favorite celebrities. But after watching that advertisements, you tend to purchase that product. So here, when we talk about misleading advertisements, let me put you a disclaimer that I'm not at all against misleading advertisements. I'm not against the industry, but no doubt advertisements gives, in fact, a freedom of choice for the consumers. We can choose a lot of variety of products which are there in the market. There's no doubt about it. But basically, when we talk about misleading advertisements, it's basically violating the several basic consumer rights at a larger extent. So when we talk about misleading advertisements, it's mainly infringing the right to information, right? Because you all know what are the basic consumer rights. I don't have to tell you in detail. But when we talk about misleading advertisements, your right to information, right, about the product is infringed. Your right to choose the product in the market is infringed because it's mainly misleading in nature. And also the last one, that is right to be protected against unsafe goods and services, as well as UTP, that is unfair trade practice, is also infringed at a larger extent. Thus, now there we can say that yes, there's a need, there's a requirement that such misleading advertisements has to be regulated. Coming to international scenario, I'll be very quick enough to glance the international scenario. I think you all know what are the international guidelines from UNGCP of 1986, right? It is also enshrined in part 3, part C, and part 4, which deals with the principles of good business practices, which is mainly emphasizes on the disclosure and the transparency of the business, and as well as United Nations Principles on Business and Human Rights 2011, which mainly states the 3 important guidelines which has to be implemented in the United Nations states, which is mainly the state has the duty to protect the human rights. Second, it is also the responsibility of the corporate to mainly respect human rights. And the third one, which is much more important, is that the access to remedy for the victims of business-related abuses. So these are the 3 main guidelines which we see at the international level. Coming quickly to the Indian perspective, I don't have to tell you about the grand now. We cannot go to consumer law without going to the grand norm of constitution, right? There are various other articles which mainly speaks about freedom of speech and expression, but we also know that the state can impose reasonable restrictions if it is in the interest of sovereignty and integrity of the country. No doubt, as I told, freedom of speech and expression, freedom of carry of business and occupation, we all know all the fundamental rights and also the the principles of state policies. So these are the various articles which mainly govern how the state, how is the state's duty to protect the consumers under Indian Constitution. Now, coming to whether an advertisement is a boon or a bane, yeah, we can see into 2 facets. It's a coin of it's a 2 faces of the same coin. No doubt, at the one end, we need advertisements because it mainly gives us a freedom of choice, information, right? And at the other end, we are also being exploited to a larger extent. Now, let me going back to the legislative perspective, the framework of the Consumer Protection Act 1986. As I told, Consumer Protection Act, the parent act, that is 1986, it had a single provision of section 21R, which mainly defined about the term unfair trade practice. No doubt it has a very lengthy entire provision of unfair trade practice which runs to 2 pages, but hardly a single provision or subsection you can say it had mentioned about the that is section 21R subclause 6, which mainly said about the makes a false for misleading representations concerning the need for or the usefulness of any goods, or it might be any services. So this was only a single provision if you consider that in the earlier act of 1986. But comprehensively, when we, taking a comparative study, we also know that UK, US, and the other developed countries have a very stricter laws when we consider misleading advertisements, and they were very clear enough as to what exactly is misleading advertisements, and they also had, the definitions regarding that, which mainly says that if this is something which is very deceiving or it is likely to deceive to those whom it is addressed or for whom it reaches. And also they were very clear enough to say that any reason for being very deceptive nature which is likely to affect the economic behavior of the consumer. Coming to the new act, which is very, very important, and I would like to emphasize on this section because this section I'm really I can say that it is a very comprehensive definition where the advertisements has been defined in section 2.1 of Consumer Protection Act 2019. Now, friends, you can see that the definition, which is not just exclusively there of print and online, but they have mainly mentioned it as anything which is audio or visual publicity, which is representation, which is an endorsement, or which is a pronouncement also, which is made through the means. They have very, very clearly, I would like to emphasize this, that they have also exclusively said the means. It might be light, sound, smoke, gas, print, electronic media, internet, and website, which includes any notice, circular, label, wrapper, invoice, or any such documents. Now, friends, you can see there that this means that they have not, left any anything unturned, any note stones unturned, because they have even included light, sound, smoke, gas. Can anyone think, or I can just put it across to you just for a food for thought, that they have also anticipated that we never know, after certain years ago, we will also be able to advertise something in the gas, in the form of a gas, in the means of a gas, or something in the smoke, where a company may come and try to endorse its brand through a smoke, through a gas in the air, and later if it's misleading, they cannot come under the purview of this definition if it is only restricting to the online or print media. So this definition, I think it's very, very exclusively, comprehensively made, that it is also including the light in the way of a light, smoke, gas, sound, and everything which is coming under the purview of print, electronic media, etc. is concerned. Now, coming to another very important definition with regard to misleading advertisements, this definition has been exclusively brought under this this act, which was not there in the earlier act, that is 1986, because here again they have very clearly mentioned what exactly is misleading advertisements. Now, friends, whatever may tend to me, which is a misleading advertisement, may necessarily not be a misleading advertisement to you. So to make it very clearly as to what advertisements tend to be misleading advertisement, it's very, very comprehensively given in section 228, the section 2 clause 28, where it says that misleading advertisements in relation to any product, or it might be any service, which means an advertisement where it is falsely describes of any product or service, right? Second, there should be any false guarantee for that, which is likely to mislead. Okay, it should be also looking like to be misleading the consumers with any perspective, with any criteria, whether it might be your nature of the product, it might be your substance, it might be the quantity of the product. See, quantity, I'll just give you an example later on, and quality of the product or service. Right? They have covered everything as to what exactly, even if it is a false guarantee with regard to your product, quantity or quality, that will also be included in this. Third, it also says that anything which is conveyed expressly, right, through print or through mentioned in someone on the product, or it might be orally, or it might be implied representation, which if made by manufacturer or seller, right, that manufacturer or the seller or the service provider in cases of service, thereof would constitute to be an unfair trade practice, right? Fourth one, which is much more important, which is deliberately conceals important information, right? Now, this is something which many times many consumers would have a point of discussion, because many times we don't get, the genuine information has been concealed. Deliberately, they have concealed the facts of the product. So these are the four points where they have exclusively brought another definition of misleading advertisements, which was not there earlier. And now I think it has been a very clear picture as to when an advertisement is being on air, we know where exactly, whether it comes under the definition of section of misleading advertisement or no. Coming to various other advertisements, which is just for your general view, that there are various advertisements you might have been heard about it. That is, it is surrogate advertisements, comparative advertisements, bait advertisements, and puffery. I think many of you all might have seen such advertisements where, you know, these surrogate advertisements is nothing but, you know, they are the advertisements which mainly are banned products, but they are masked under another product just to push their product in the market. So you might have seen this, you know, products, or it might be Royal Challenge, where they usually advertise during the cricket match when it's going on, or it might be Wills also, which cannot be advertised per se, but they try to put it in across through various other modem of communication. Comparative advertisements is nothing where two competitors or two manufacturers try to compare their product with each other. You know, where you can say that we have, you know, much more, the world's #1 largest, or you can say 100% Jummy Chuck. Some sort of advertisements are also there, where they try to compare it with their competitor's product. But here, when we say about that, in India, comparative advertisement is not that illegal, but you know, you try to defame or try to put a direct blame on the other product, saying that so and so product is not good. That is not possible. That is prohibited. But you can always compare the product with the other, the manufacturer or your competitor. Coming to puffery is nothing but where a advertiser try to exaggerate his product. Like, for example, if he's a coffee producer, he may say that it's the world's #1 coffee, or world's biggest or largest food chain manufacturer, something like that. So anything which they are exaggerating is coming under the puffery. Now, coming to very again important part is the endorsement. I think, right, this is something which mainly brought attention in the Consumer Protection Act 2019, because this was something which was not there in the earlier act. And I think you all are aware of the Maggie case, which is rightly called as Nestle versus Union of India, which happened in November 2015 in Uttar Pradesh at the initial stage, right, which dragged on till 2019, where we all know that what were mainly the allegations against the Nestle, whether it was more MSG and lead, and it was many of their varieties like, you know, oats and atta noodles and many other varieties which were not approved by FSSA. And another very, very grave thing which came across Nestle was the celebrity endorsement, right? You also knew that, I think, Madhuri Dixit, Amitabh Bachchan and Preeti Zinta were mainly held liable because they said that, taste be healthy, or something like Madhuri Dixit went on to say that Maggie is a healthy breakfast. So all these endorsement was mainly brought under into the big picture when this case came, that is Nestle versus Union of India. But here that was not the initially, but let us see what exactly the definition under Consumer Protection Act 2019 mainly says as to when can we make these endorsers held liable under this 2019 Act. So here, this section says that any message, any verbal statement, or it might be even demonstration without any oral communication also, or it might be any depiction of the name, right? It's very clear that even if they don't say it or orally, but even their name or signature on the said product is also will be coming under the same purview. Signature, likeliness, or other identifiable personal characteristics of any individual, or any depiction of the name or seal of any institution or organization which makes the consumer to believe that it reflects the opinion, finding, or experience of the making such endorsement. So friends, you can see here that the entire definition is so comprehensively made that even if endorsers only try to put his signature, which we many times see, they put mainly endorsed by so and so. It might be a cricketer, it might be a film star, or some other celebrity, or from sports celebrity, or someone from there. So here they have included everything which mainly says that what exactly is called as endorsement, so that no endorser can go caught free saying that, oh, I never endorsed it orally, or virtually, or with my verbal communication, but I had just signed it on that without knowing whether the product is true or no, whether it's genuine or no. So here it is mainly making the endorsement very comprehensively, that the endorsers, whoever is coming to endorse the product, has to be very, 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 judiciously and carefully doing the product endorsement, because it is not only impacting, for the advertiser to make the product or to come up with the advertisement, but also it is impacting the larger mass of the consumers who are mainly having the impact of this endorsements done by these celebrities. Coming to restrictive trade practice, it is a very another section of section 241, where it is mainly saying that in case of any manipulation of prices, it might be conditions of delivery which has been given. In such cases, they are mainly coming under the ambit of restrictive trade practice. Coming quickly to unfair trade practice, section 247, which says about false representation, right? Misleading information, warranty or guarantee not based on adequate or proper test, misleading affiliations, or disparagement of any wrongful facts. So these are the 5 things which mainly are covering under the UTP. Now, coming to a very, very important section, that is section 10, which mainly says about the CCPA, that is Central Consumer Protection Authority, where mainly they have the duty to regulate matters which are relating to violation of rights of consumers, unfair trade practice, false or misleading advertisements which are mainly prejudicial to the interest of the consumers, to promote, protect, and enforce the rights of the consumers at large. And apart from this protecting and promoting, they also have a very, very important powers which is given to them, that is, they have suo motu powers to do inquiry, investigation, and also pass orders. This is something which has mainly come under CCPA, which was not there earlier, and this is something which can drastically increase the way the enforcement can be done to a larger extent. So these are the major the significant powers given to CCPA. The other things are they can also issue directions, and other than that they can also bring consumer awareness, as it was there earlier with the councils and the other hierarchy of the commissions. Coming to the very important section, that is power of central authority to issue directions and penalties against any false or misleading advertisements. So friends, this is something which is important, where as I told, this is a significant provision which is given to CCPA, where if they are satisfied with any investigation of any advertisement which tends to be a false or misleading advertisements, they can issue an order, they can give directions for the concerned manufacturer, or it might be even an advertiser or the endorser, to mainly, firstly, they can discontinue the advertisements, or in case if they if they have something which is there which they can modify, saying that you can rectify or correct the advertisement, they can do so within the stipulated time. Or if the central authority is also of the opinion that they can have a they can also impose a penalty over this the manufacturer or the advertiser or the endorsers, they can also make the endorsers held liable, and the penalty which can be extended to 10 lakh rupees, provided even the central authority, in case if they feel that the person has again subsequently made the same offense again, that will be extended to 50 lakh rupees to the the endorsers. And also, apart from not only the penalty, they have also made that person, they can also prohibit the endorsers from doing such false and misleading advertisements with regard to any product, or it might be any services, and they can they can suspend him, or you can say they prohibit him to do that for 1 year. Coming to very important another thing which is there, what are the exceptions? What in case if he's a genuine endorsers, where if he wants to get an exemption, what should he do in case if a person wants to endorse the product, but what are the mainly things which he has to take so that he doesn't fall under this? So here the endorsers has to exercise the due diligence to verify that the veracity of the claims which are made in the advertisements with regard to any product or service has to be looked into. So it means that it is mainly putting the responsibility on the endorsers, that in case if you want to promote a product, if you want to endorse a product, you have to take due diligence to see that the product is genuine, whether if you're promoting any food product or health drink for children or any other endorsements, but you have to check whether it is scientifically proven, whether you have to take that due diligence on your part. If he proves that he had published or arranged for the publication of such advertisements in the ordinary course of business, provided but no such defense will be available to him in case if he has previously known or knowledge he has the knowledge that the order passed by the central authority for withdrawal or modification of such advertisement. So it means that if a person is an endorser, if he has to take due diligence in while making a endorsement, he has to take due care and diligence, saying that he had made a proper study whether it is scientifically proven or not, and also if he knows that the CCPA had already told the advertisement to be withdrawn, but still he tries to promote the same product, then again he will be coming under the ambit of the section. Now, what about the punishment? So section 89 also very clearly says that any person who causes to false or misleading advertisements, whether it might be a manufacturer, it might be a service provider, he'll be fined, which may be extended to 10 lakhs, and also imprisonment, which may extend to 2 years. But in case of again subsequent offense which is done by the same person, it may extend to 5 years, and also it may extend to 50 lakh rupees. Now, apart from chapter 3, which is also mainly telling about the CCPA powers and functions, and chapter 7, which I feel that offenses and penalties, which is very, very another significant chapter, apart from the other 3 chapters, because initially when you see the Parent Act, there were not much grave or stringent penalties before, which mainly made the trader or the manufacturer to go scot-free by just paying them 5,000 rupees or 10,000 rupees maximum. But here, the chapter 7 is mainly emphasizing on the penalties provisions, which are much more very stringent when compared to the earlier act. So see, when you see the tabular, you can see the section 88, which mainly said about the penalties for non-compliance of the direction of the central authority, right? CCPA, if the CCPA has come up with the order and the manufacturer, the trader doesn't comply with those order, then the person will be imprisoned for 6 months with fine, and the fine may extend to 20 lakh rupees, or it may be both, that is imprisonment and the fine. Section 89, which also very importantly, as I stated before, that it is mainly dealing with false and misleading ads, which has 2 years of imprisonment, which may extend to 10 lakhs rupees as the fine, and subsequent offense, it is 5 years of imprisonment with 50 lakh rupees as the penalty. Section 90, which says about adulteration, which earlier we did not have such a grave or a stringent provision. Here it says about the punishment for manufacturing, for sale or storing, selling, distributing, importing products which are mainly containing adulterants. Here, if you see, there's a lot of other provision, like other the range of penalties which is given is something which was not there earlier, that it might be 6 months imprisonment till the maximum is 7 years in case of death, and imprisonment not less than imprisonment, life imprisonment, and a fine not less than 10 lakh rupees, which was not there earlier. And another very, very clearly they have stated with regard to penalties is that they have segregated each and every offense. There's no one penalty for entire all the all the offenses. They have very comprehensively and very systematically segregated each and every offense has a different set of penalties, where they have also included the spurious goods, where included where in case of any spurious goods which are, whether the person is in the chain of manufacture, storing, even the person who is selling, or even case distributing or importing, he'll also be included under the section 91, where the the penalties also are of a similar nature of the adulteration. Now, let me give you a very quickly a very a brief idea of a comparative study. I think I'm running out of time, but I'll just take quickly through the other comparative study. I will also state you why exactly I'm taking this comparative study also. So when we talk about UK, we have a similar sort of Consumer Protection Act 1987, where Part 3, Section 21 mainly deals with misleading advertisements. They also have Consumer Protection Unfair Trading regulations, which are mainly again with regard to UTP, RTP. They have the provisions where regulating exclusively on those, the regulations are being there. Consumer rights payments surcharges regulations, which is mainly regarding the MRPs. If they are charging them more than the MRPs, they have a different legislation called as Consumer Rights Payment Surcharges Regulation 220. Now, just quickly, I'll just take you to few of the cases. In this case, one more thing I want to tell you here is that in UK, they also, apart from the legislative framework, they also have something called as Advertising Standard Authority, which is like a self-regulatory, voluntary and self-regulatory authority. But the only you can say they have this Advertisement Standard Authority, something similar to ASCI, which is Advertisement Standard Council of India, which is there in India, right? So here they had come up with few cases which are almost similar to how it is there in USA with regard to Federal Trade Commission. So coming to here in this case of Director General of Fair Trading, this was a case where a Speed Slim was the product which was mainly advertisement, and it mainly claimed that using it regularly on a regular basis, they had a permanent weight loss which was guaranteed in this product. Mainly they said that the product had some sort of scientific ingredient which would break down all the the fat which is accumulated in the body, and they said that this was mainly scientific in nature and it was totally 100% guarantees. So when this ad was being mainly taken by the ASA, it was unable to substantiate whatever they had claimed in the advertisements. So so later the ASA had to totally ban them from the products. Coming to very, I think you might have seen this, popular celebrities. Here, this was an advertisement mainly from L'Oreal, advertisement which mainly featuring the Julia Roberts, who was mainly promoting the Tint Miracle, which was a foundation per se. And also there was another celebrity, Christy Turlington, who was mainly featuring another product called as Eraser, saying that after using this product, they were looking very bright, and all the signs of aging were not visible, and whatever the fine lines and the proof it was there on the face, that was not visible. But what happened is that after this advertisement was aired, and after this, the next day itself, the celebrity was been taken, was caught in the media, and the ASA had fined the company saying that this is not true, the advertisements is not true. So later they were being fined, and they were being mainly told to ban the advertisement. And also the L'Oreal had admitted that they had used digitally to make the image without any fine lines or all this. Digitally they had mainly put filters and all this. So these were the another two major case laws which we can see in UK. Coming to USA, I think USA has a very, very, very stringent laws, because there we know what is the role of the FTC, that is Federal Trade Commission, are doing with regard to unfair trade practice, or it might be misleading advertisements. And here when we compare it with other laws, USA has a very, very stringent Federal Trade Commission, which is also backed up by the Advertising Self-Regulatory Council, which was initially called as Better Business Bureau. So here, one positive part we can say of USA is like similar to on this parallel line of India, where we have ASCII, the same way they have the FTC, which is mainly backed up by the government, and also they have much more. They also have a similar sort of self-regulatory body, that is Advertising Self-Regulatory Council. But the only thing is that they can enforce the orders which the regulatory authority is coming up. So it is mainly backed up by the government. Now coming to very quickly for these cases, I'll just take just 2 minutes for this, to just explain this. So first case is Marcus Wilson case, which was mainly relating to a Lay's chips packet, where they advertised that it has a very healthy snack, because it contains 0 grams of trans fat. And this said snacks, that is the Lay's chips, was mainly good for certain group of populations, which maybe even the people from diabetics, children's, adolescents, even elders and pregnant women can consume, because it was fat free, or 0 grams of trans fat. But later it was found that it was not good for the any of these group of people. So but the company here, they had mainly failed to mention that every 50 chips contained more than 30 grams of fat. But because see, this is something which is very important, because whenever you take a purchase a product, you obviously see the ingredients, you always see how much of calories is there in each and every ingredients which is mentioned. So here this product was also been banned by taking whatever the claims which they had made. Coming to the next, Lauren versus Avian products. This was a range of entire products which was mainly coming from the Avian products, which mainly claimed that after using such products, of their variety of products, cream products, which they claimed that they used to repair and damage the tissue, and they mainly boosted the collagen in the skin, and which mainly created a fresh look on the the person who is using that. So again, this was again a misleading advertisement. So this was again lifted. It was mainly banned. Coming to the next, Carol versus Maybelline. This was another product where the complainant herself, alleged that, they stated that it was super stay for almost belonging for 14 hours, but it was not true. So the complainant alleged that whenever she had a meal or a drink, it used to swipe away. So this was another case which was again brought into the for the FTC. And the last case was Caladin versus Coty Inc. This was mainly a case where a product of Coty, that is Rimmel London Lash Accelerator Mascara. This was another product of which mainly claimed that the eyelashes would grow 37% more in a month and would lead to a higher amount of eyelash growth on a regular usage. But again, when the FTC was mainly had this case came to them, they were not able to substantiate whatever the claims were. So all these cases, whenever it came to the concerned authorities, they had to prove the claims which they had done, which were all the 4 cases were unable to claim, were not able to substantiate whatever they had claimed. Coming to New Zealand, the reason for me to take this New Zealand is it is on a similar footage of UK and India, where we also have same sort of legislation, that is Fair Trading Act of 1986, where they also have provisions which is mainly dealing with false and misleading advertisements. They have to be backed up with proper scientific evidence. They also bring into bait advertisements in case if the stocks are more, and if they're just trying the manufacturer is just trying to push their product in the market, they are trying to dupe the consumers, giving them misinformation, right? If similar to ASCII, we also in New Zealand they have ASA, self-regulatory bodies, and here they also keep changing their code of conduct for every 5 years, and they say that the codes are just in supplements to the law, but they cannot replace the law which is already there. Coming to two more cases of New Zealand is this Go Healthy cases, which is this is a health supplement which was mainly found about which they said that in this case they said that mainly it was made in New Zealand, but the truth was that all the products which was used in this product was mainly imported from the other countries, which was nowhere disclosed in the product, which was mainly concealing the facts of the product. In another case, this was a case of Vodafone, where they said that it was mainly a broadband everywhere, and they also said that they could get an extra like airtime is nothing but talk time free, like which had mainly for this super prepare, that was the package which was given to the consumers. So mainly these 2 cases which came by the ASA in New Zealand. Coming to India, which is again of our interest, is ASCII. I think you all are aware of ASCII, that is Advertisement Standard Council of India, right? So here also we know it's a self-regulatory voluntary organization. It doesn't has any government authority where they can enforce the orders which they are giving. It's mainly a voluntary self-organization, which is mainly constituting all the advertisers, advertising agencies, and they group voluntarily come up as an ASCII. So here, the only flaws you can say, or the only thing I want to point out here is that no doubt whatever the advertising ASCII is coming up with, the complaints are going to ASCII. Like any consumer can file a complaint against us before the ASCII with regard to any misleading advertisements. But the only thing they can do is they can ask the said advertisement to withdraw or to modify it, right? And they can also bring an awareness to the consumers, but they cannot enforce it in case if the advertiser don't comply with the order. That is the only lacuna with regard to ASCII is concerned. So here you can see that the remedy which is given by the ASCII is either to modify it or either to review the advertisements, but mainly they are lacking with the enforcement powers, and they lack quick redressal, because it takes a lot of time. Because see, for example, if today I have complained to ASCII regarding a certain product of any of the product which is misleading, let's say, like for example, any Horlicks which says that stronger, sharper, bright, sharper, and if by the time I go and complain it's already been aired, it's already been impacted to the consumers, already the wrong has been done, the damage has been done, because it's already reached to the consumers. So here it's lacking a quick redressal, lack of awareness. Many, I think almost 99.9% I can say that many people, even the population of India, especially the Indian consumers, are not aware that such and such organization is there where they can go and complain regarding any misleading advertisement. Forget about complaining, they don't even feel that is a problem per se. So right, so the lack of awareness is also there. role of the state and self-regulation by the MNC. So this is another thing which is very, very important, because it has to come within the company that they has to self-regulation among themselves to not promote such misleading information or misleading advertisements which are mainly harmful to the general public, or especially it might be a children's person, right? So there's a lot of role of the state which also comes into, and also the self-regulation from the MNCs who are mainly coming up with such advertisements. Another important thing is Gamma portal. Now, what is Gamma portal is nothing but, I think many of them may be also knowing that to address this issue of misleading advertisements, Ministry of Consumer Affairs, Government of India had launched a portal, online portal, which is called as Grievance Against Misleading Advertisements. In short, it is called as Gamma. You can also see the link there. So what happens in this website is that if you go to the link, you can also take a photo, video, or any picture where you feel that any advertisement is misleading advertisement, that can be taken and that can be uploaded on this website, and they can give a complaint to the Gamma, that is the authority, that is the Ministry of Consumer Affairs. Now, my only humble submission would be that, as I think many of the presiding officers, the ministry, the presiding officers and the ministry officials may be also on the on the same webinar. I only request is that, and I think in the previous sessions also, Miss Nidhi Khare ma'am also had told that the CCPA is in the process of forming in IIP in New Delhi, and they are all set with the infrastructure and everything. So I think this would be something which you all can start with, because here already the Gamma portal is there, where they are already getting so many cases there with regard to misleading advertisement. So here, when you're focusing on that is National Consumer Helpline, I think Gamma portal on the other hand also will go hand in hand for you all to address the issue on misleading advertisement, because everything is already coming there online. So once the CCPA is starting with the functioning of that, I think these two portals, like National Consumer Helpline and Gamma portal, will also be supplementing for your efforts, where you all are putting it across for the mainly curbing for the misleading advertisements. That would be my humble submission for all the authorities, whoever is there in the portal, in the webinar. Coming to some of the cases, I think you all know which are the cases. I'll just quickly take. There was also a Dabur Chyawanprash, which mainly claimed that it's 3 times more immunity which is giving for the kids. But again, this was banned because they were not able to substantiate the claims. There was also Kellogg's challenge, which was given where, having the 1 bowl of Kellogg's, which, for a dinner and for a breakfast, which would decrease the way for a weight loss within 2 weeks. That was also not substantiated by the Kellogg's company. And neither they had, stick to the time limit, that is the duration of the disclaimer on the television commercials should were not for less than minimum 12 seconds, and whatever they had written, that the disclaimer were not been legible for the people to see as to what were they written in the disclaimers. Coming to another advertisement, I think you might have also seen some shampoos which has been mainly taken up by ASCII, saying that a shampoo which was mainly Sunsilk, which said that fruit vitamin shampoo which mainly contributed to hair growth. But later when ASCII, this case was coming before the ASCII, they were unable to, substantiate their claims, and thus it was discontinued. There are various other products which was coming, which which made tall claims like no germs, no cavities, but again that was an exaggeration, and the advertisement could not substantiate whatever the claims which were made. Coming to another Lifebuoy Plus, which was again telling that it was certified by the Family Physician Association of India, which again they could not substantiate, so again they had to withdraw the product, withdraw the advertisement. And the another thing was Alpha water purifier, which says that which was very clearly misleading, that was boiling water destroys viral salts and minerals, which was again found to be misleading, which they could not substantiate, so they had to modify the advertisement. So at last, I would like to mainly conclude with certain few of the things which I think that is very, very required, is that I think India is already on its way forward. That is when the Consumer Protection Act 2019 has come. I think it's a very welcome step for the Indian consumers, looking forward for all the other chapters. Now, I'm not only talking about misleading advertisement. It might be product liability, it might be mediation, it might be a very comprehensive CCPA which has come, which is much appreciated, and I think it's a very we are expecting a lot from CCPA as of now, because but the only thing is that legislation no doubt is in place, but the only thing I think is that a lot of efforts have to be done from the common consumers per se, not only as with awareness is concerned, but also you need to be a very smart consumers. Apart from that, the implementation part on the presiding officers, the awareness among the consumers, because many people even don't know that the new act is in place. So we have to have such training programs, training the officials, training the consumer redressal commission members, so that we go hand in hand with regard to the new legislation is concerned. And also with regard to something which I had always been, there is no doubt we have a exclusive penalty provisions, but something like a policy where a public naming and shaming policy can also be brought into, like similar to the UK and US. I don't know whether it be right now been taken, but something like, for example, I think we know that in US, whenever there is coming up with an advertisements, any company which is coming with a misleading advertisements, they have to, if that they cannot substantiate later on, they have to withdraw it, or they have to mainly make it corrective by publishing it, right, by publishing it in the public. So something like in where the manufacturer or the advertiser have that policy among that they should not advertise anything misleading, which will be a much more burdensome for them to later rectify, or doing something like coming up and apologizing in the public. So that is something which I always suggest, to something like a very stringent penalties or stringent measures which can be taken against such company, like public naming and shaming. Coming to celebrity endorsers, they should also have certain sort of social responsibility and self-regulation among themselves before they go for any endorsement with regard to misleading advertisement in concern. So that has to come again within themselves, to have a self-regulation among themselves. Coming to the corporate, I think they should also be given a corporate corporate consumer responsibility similar to social CSR, that they should be some sort of code of business ethics before coming up with certain misleading advertisements. And also the redressal mechanism should be you should be very user friendly, consumer friendly, and very simplified in nature, so that the consumers are literally very encouraged, and they should not feel that it is a very cumbersome procedure, that even for complaining a misleading advertisement, they should not go through a lot of hassles. So it should be simplified, and something consumer friendly procedures have to be taken care of, so that such incidents of misleading advertisements can be at least reported. Forget about going to that, but at least reported. The menace of misleading advertising is largely unregulated because of the ignorance. That is something which I have been telling since beginning, that because of the ignorance, I think they're mainly encouraging the advertisers or the manufacturer to do much more misleading advertisements. So it is also the higher responsibility lies on the consumers also, that whenever we see a product, whenever we see an advertisement and we see that it is misleading, we have to take it seriously. Till today also, I don't think so, if any product, if we see any advertisement, whether even if it is a pamphlet, wherever you see, and if you know that it is misleading, you don't tend to take that into consideration, because you don't think that it is a problem. So once we start taking it as a problems, once we start addressing that, then only we can address it to curb the misleading advertisements to a larger extent. So by this, I would like to conclude. Thank you so much. Before that, before I conclude, this is just for your information. This is nothing. This is a source which I had taken from Times of India, and I think Professor Patil also is, has been circulating this. That on 24th of this August, this is an update that to curb misleading advertisements, the central government, that is the Ministry of Consumer Affairs, is mainly studying the courts of New Zealand, UK, and US courts, mainly as to how they can bring such courts into into our country. Mainly if you see this, this has mainly come just 2 days before, a couple of days before, where the center has told that apart from ASCII, the center will also, the Ministry of Consumer Affairs also will be coming with certain code of conducts, where they all the advertisers, manufacturers, they have to comply with these codes of conduct. So very soon they'll be coming up with these codes, and they'll be also publishing it on their website. And all the manufacturers and traders have to make sure that this will be mainly brought into, and once it comes, I think it will be much more into a streamline, rather than only depending upon the ASCII, which is a very voluntary and self-regulatory organization, which is not binding on the advertisement. With this, I would like to conclude. Thank you so much.
Thank you, ma'am. Thank you for the excellent presentation and briefing about the misleading advertisements. Now I request Professor Ashokar Patil to take over the question and answer session. Over to you, sir.
Thank you, Akshay, and excellent presentation of Anita. And in this session, Anita and myself will clarify any questions asked in this chat box. So first question is whether an advertising agency as a creator or canvasser of the misleading advertisement be liable under the Act, because more often than not it is their brainchild in creating misleading advertisement. I repeat it, whether an advertising agency as a creator or canvasser of the misleading advertisement be liable under the Act, because more often than not it is their brainchild in creating misleading advertisement. Yeah,
Yes,
Anita.
sir. Okay. So I would directly say yes, they would be held liable. Whether, see, if you see the section also, it is not saying that a person who is directly, or whoever is the brainchild, or whoever is the idea of coming up with such advertisements, it's not mentioned. Whoever is endorsing, so the person who is coming up with the advertisements, they will be held liable. The advertisers as well as the person who is mainly endorsing. It might be a celebrity, or it might be any person like any sports person who is mainly endorsing. They will be held liable. There is no any exemptions given that who has come up with this idea. They will be held liable if it's coming with the advertisers or the endorsers.
Yeah.
So if you would
Continue.
like to add.
Yeah. See, as a consumer, I'm seeing the advertisement. Who has done that misleading advertisement? I don't know. Is it a advertising agency? Is it a manufacturer or whoever intermediary? I don't know. As a consumer, I saw that advertisement. It is a misleading. My issue is that point. So I will file a case. Even we don't know who is the advertising agency has done it, because it comes in the name of the manufacturer. So we are filing against the manufacturer. As a consumer, we are filing a case against the manufacturer. If there is any deal between the manufacturer and the advertising agency, then you take separately. But for consumer, manufacturer who has issued this particular advertisement, you directly held liable. Internally, you do whatever you want. That's why when the consumer don't know who is a wrongdoer, sometimes if we know the intermediaries, we will file a case against all those people and we will ask a prayer jointly and severally held liable. So we want compensation jointly or severally. Let them fight between themselves. Whosoever has done a wrong, ultimately consumer wants compensation. So in that angle, it will go. Yeah. So next question is, in case of misleading advertisement, if company mentions a disclaimer that it varies from individual to individual, then company can defend on disclaimer. What is your view on this?
Okay. So so you would like to first take it, or shall?
Yeah. So here disclaimer, whosoever gives the advertising agency gives a disclaimer. So ultimately it look into the layman's, as a consumer, how he see that particular advertisement. On that basis, it will be decided, not on the disclaimer. Again, it depends on what type of advertisement, what type of disclaimer, on depending on the each advertisement that will be assessed. So that is a general answer from my side. Anita?
I would just like to add, like, for example, let me give you an example here. For example, if you're giving a disclaimer saying that we have been tested on so and so people, like, for example, let me take an example of health drink. Okay, they say that, for example, let me put it across that Complan only. That Complan says that 3 inches will be growing for the children who is taking the Complan. So the whatever the disclaimer they are putting, that also has to be mainly reasonable. They cannot, if only because of the sake of putting disclaimer, they cannot say that the results may vary each other. If you're telling that 3 inches will be grown if a health or from a health drink, that has to be substantiated from as to how many people were being tested. You can't tell that only 8 people were being tested with this so and so product, and we saw that there was an increase in 3 inch. They cannot do so. See, for example, I'm telling you, the advertisers also know how to use the provisions and how to make the practice, right? They also know how to escape from the liability. So it is also very, very prudent that whenever they're putting disclaimer, not just because of the regulation says that they have to put the regulation, they cannot put that. They have to be able to substantiate that, or how many percentage of the population they have tested and they've seen that so and so using so and so product, there was an increase in 3 inches of the height growth of the child, right? That has to be genuinely seen. Just because of the namesake, they cannot put the disclaimer. That is again sort of one there is, we can say that is another sort of misleading information they are giving apart from the major principal offense they are doing. Thank you.
Yeah. Yes, the sample size of the survey test is very important. And when you are making it a general statement, general guarantee, warranty for whole India by doing for testing on 4-5 people, and again, those surveys, it depends on who funded that survey. So if manufacturer himself fund that and he himself controls that, then automatically the sample, I mean, result comes in his favor. So all those things will be counted. And also which government authority recognized, authenticated that particular claim. So all those things will be counted before deciding that particular thing. Next question is, what is your view on using class action to deal with misleading advertisement?
Yeah, I think there is no other variation that class action suit, whether it's a class action suit or whether it is an individual consumer is concerned, it can be taken in par with each other. So whether if it's coming as a PI, also that will also be taken as a misleading advertisement case which is coming across. So I don't feel there is any difference whether it is a class action suit, but in fact it is much more having a lot of gravity, because when it is a class action suit, we'll know that many of the consumers have been adversely affected by their rights when it is concerned with any misleading advertisements is concerned.
Yeah, here if it is a misleading advertisement, especially under the authority can take it as a class action if it is affecting the whole class of the consumers, and suo motu they can take a action against that particular misleading advertisement. And also sometimes there is one provision where it is misleading advertisement is there, but one person or two people have gone to consumer commission, but consumer commission found that it's unfair trade practice, misleading advertisement, but they are not identifying who are the sufferers, means other consumers who suffered from this misleading advertisement or unfair trade practice. Then the under section 39, in that particular clause K, 1K, it is clearly mentions that the commission can order 25% of the value of the defective goods sold. That should be the penalty, that should be the fine on those wrongdoer. So whosoever by doing misleading advertisement, if he sells, to that extent a penalty can be imposed on the commission, on those misleading advertisers or wrongdoer. Next one, nowadays there is a trend, especially in TV advertisements, using the children to promote mainly mosquito repellent and many other products. We treat children as a immature in taking decisions. Whether guardians can be held liable for such child endorsing the endorsement.
I think this is a very pertinent question, because I feel it very interesting, because when we talk about misleading advertisement, and right now when I spoke about the endorsers, so this is a very pertinent question when we talk about the role or the due diligence which has to be taken. So yes, I think that has to be taken care of, because when we talk about not only celebrities but also the endorsers, whether even if he is a common man, the parents have a role to play when they are trying to endorse a commodity where the children are involved in that. So it makes no difference that the role of the guardian or the role of the parents is at a higher state, where they have to take that due diligence, and whatever as I mentioned, that they have to take diligence. So this will also be taken care of, and there will be no any exemption whether it is a child or whether it is a minor or something like that. Yes, sir, if you want to add.
Yeah, that's the thing. When child is not able to take a decision, what is good or what is bad. So that's why immunity is given to the minor children. So in that case, guardians who made that child to do that, so guardians are responsible for whatever on their direction child is doing. So the parents also should look into the content or in depth of what is that advertisement. Is it true? That's why she said use the word due diligence. So that has to be taken care. And next question is on the same point. What do you mean by due diligence under
Yes,
Consumer
this is a
Protection Act?
yeah, this is something which again we can talk about that due diligence through a larger, to a larger extent. But here, due diligence. Let me give you a small example because I know I'm running short of time. But due diligence is like, for example, let me take you for the same example. Like for example, you give an example of mosquito repellent, which says that, let me put it across like this, that if it is saying that something natural or something herbal, if the child is coming with such advertisements, so the responsibility lies on the parents to check if they're saying that, if the said advertisements claims that it is 100% natural, safe, or something like Ayurveda, they have to take due diligence. Like how, now if you ask me, how can they take due diligence? In this example, they have to mainly, they have to see what are the backups. Like for example, if advertisers are saying 100% safe and Ayurveda or something which is used with some natural products, they have to make the test by themselves. Like, they have to look into the genuinity or they have to be able to substantiate the product before the advertisement. So it lies on the person who is endorses, whether it is celebrity or it is a common man. He have to take efforts to see whether the said product, whether it is 100% safe, 100% natural, or something like that, to say he has to invest in that and check whether the product is true or not. Because in case if you don't do so, later if it is found that it is misleading, he will be in trouble from the CCPA, where they'll be issuing the order against him. Either they'll be banning him, or either they'll be imprisonment, and fine will be put on the endorsers. So this is just an example I'm giving. So it is mainly due diligence. In common language, I can say that they have to make a probe, or they have to mainly check if the product, whatever they're claiming, is true or not.
Yeah. In continuation with Anita, see, as an actor, if a manufacturer comes with some particular advertisement, if you drink this particular a particular company, then this will be the change. So he sometimes he may not drink and test sometimes, but he can look into the scientific documents of the manufacturer who is advertising. So what is that what is that survey, what is that research on which he has come to conclusion. And to protect his skin, let it put that particular research or whatever advertiser or research company is saying, put it in the agreement. See, actor, actress, when they do advertisement, they enter into agreement with the advertiser or the manufacturer. So tell that particular manufacturer or the advertiser on what basis you come to this conclusion, so that you are believing that particular agreement and the statement of the manufacturer on which you are giving that particular. So like this, you have to take due diligence and you have to decide. So that is a very, very important thing. We will conclude with one particular point. Here we are already reached the time. See, under the unfair trade practice, there is a particular section 1 in the new legislation, section 2, clause 47, clause G. See, all these advertisements, what they are doing, they are giving guarantee or warranty. Tall claim is nothing but guarantee or warranty they are doing. If it is not true, it's a misleading. So this clause G, just I read for your information, it gives to the public by warranty or guarantee of the performance, efficacy, or length of life of the product or of any goods that is not based on the adequate or proper test. So that is misleading. Now, if a consumer goes to Consumer Commission and says that it's a misleading, very excellent provision in this G, clause G says, burden of proof is not on the consumer. Burden of proof is on the opposite party who is making tall claim, because all the information about that tall claim, research, everything is with the opposite party. That's why. So consumer is, once he shows, proves that he has purchased and this is the thing happened, then burden shifts on the opposite party. On what ground he is making that tall claim? If opposite party is failing to prove that what he is making tall claim is on the basis of science, then automatically case is in favor of consumer and it is proved that it's a misleading advertisement and the commission can take action. It was there in even in earlier act 1986 under section 2(1)R, but commissions are not, redressal commissions are not used this particular provision effectively. At least now onwards, they make use of this particular section so that these misleading advertisements in future, it will come down. So with this, we will conclude the question and answer session. Thank you, Anita. And now over to Akshay.
Thank you, sir. Now we end the technical session over here and we'll move on to the next session, that is valedictory session. Now I request our honorable guest speaker, Honorable Dr. S.M. Kantikar sir, member, National Consumer Dispute Redressal Commission, New Delhi, to deliver valedictory address. Over to you, sir.
Before Kantikar sir starts, just I want to put one word. Kantikar sir is always consumer friendly, always he worked for the consumers protection. When he was practicing in Shimoga, he joined a district consumer forum as a member. He got experience and his research is also on the consumer protection. And first time in India, the National Commission appointed a doctor, MBBS MD, doctor as a member. And another plus point, he got a second term. Service in the first term was successful, effective. Because of that dedication, he got a second term in the National Commission. So thank you very much, sir, for coming, and over to you.
Thank you very much. Good evening, everyone. Yes, Dr. Patil sir, he is my postgraduate PhD teacher. Dr. Anita, who spoke just on misleading advertisement, definitely it is very pertinent issue, and we have to move forward successfully to achieve the aim against the misleading advertisement. I agree, it is a difficult task. So far, I am in the Consumer Commission. We came across very few cases of misleading advertisement. Anyway, it is not the subject now. And Mr. Akshay, who I am watching since 1 week, who is very well coordinating with the speakers, the participants, and everyone. So, good evening, everyone. Today we are at the last stage of concluding phase of this national webinar on Consumer Protection Act 2019, Rules and Regulation, which is organized by NLSIU, by the chair on consumer law practice, which is headed by my professor, Dr. Ashok Patil. So on the inaugural address, I presume all participants were wholeheartedly participated in this program and on the inaugural day on 21st August, our Honorable President, Justice R.K. Agrawal sir, he spoke and he has extensively elaborated on the new provisions. What are the new provisions in this Act 2019, which came into force from July 2020. And on the same day, Ms. Leena Nandan, the Secretary for Ministry of Consumer Affairs, Food and Public Administration, Government of India, she also discussed the key highlights of the new Act, including the establishment of CCPA, which is a novel idea, and I think it will boost the consumer morale now. And it is to protect and to promote and enforce the rights of consumers. Another session, during the technical session, our additional secretary, Mr. Nidhi Khare, who is the first commissioner, chief commissioner of CCPA, which has been formed very recently, and she addressed for effective implementation of the consumer justice through CCPA. And on the same day, I think one advocate, Dr. Wagish Singh, he also spoke, and I think CCPA has more role to play in this new legislation. So apart from this, all the other participants, they spoke very well on the e-commerce transactions, mediation, and its effect, and how to resolve the consumer disputes, and just now misleading advertisement. They spoke, and it was very excellent question answer session in collaboration with Professor Patil. It was really excellent. Speakers were very learned and very lucidly they explained all the participants about the concept of new ideas in this legislation. So I am sure all the participants have gained much more information from the learned speakers on this new act. To sum up about the new act, which provides it is to simplify consumer dispute adjudication process. It was enacted in 2019, and now the rules are framed and it is implemented from July 20, very recently in the last month. So it includes, I just touch the highlights. It includes review powers of the district and state commissions, and the consumer can file the complaint electronically, and he can file the complaint from any jurisdiction. There is no need that in the previous act, where the respondent is there or where the act has occurred, the consumer complaint should be filed. That provision is withdrawn now, and he can file anywhere from the other place of residence also. And the video conferencing for hearing and deemed admissibility, because many times what we observe, when the consumer complaint is filed, for admission hearing it will take much more time. So there is a provision now, if the commission, any commission, district, state or national, if it won't hear the complaint on admissibility within 21 days, or if it won't decide whether this complaint to be admitted or not. So there is a provision now, it is deemed to be admitted. After 21 days, the complaint is automatically get admitted. So the other thing, new concept of product liability, which is very much new for me also, and I have gained much more things from this deliberation. It is a boon for the consumer to claim for compensation or the punishment to the product supplier and product manufacturer and other people. Now the last but not least, in my view, this new act will make a landmark reforms in the landmark reforms in the country in the area of consumerism. In coming days, the most important is mediation will be the most effective tool to avoid delay and to get speedy justice for the small matters. No doubt, mediation can be, the large matters can be solved by mediation, but for the small matters which are lingering on years together, that can be resolved at district level through mediation. and it is a boon. Then the central, and I think the central government and the respective state governments, now the responsibility is both the governments, they should make the landmark reforms, they should make improvement in the infrastructure of the consumer commissions at the district and state levels, because we need now more electronic media for online mediation center than e-filing, and e-court facility is the need of this hour now and here onwards. You might have experienced due to COVID, entire judicial system, entire consumer system, or any other systems, government systems are paralyzed or very slowly moving. So in future, most of the things will be on the e-courts or video conferencing that will help the consumers to reach the consumer courts, to avoid the traveling and avoid the expenses also. So it is the duty of government to implement or provide the proper infrastructures. Then next, what as a member in Consumer Commission or in this area, what I feel the members, all the members at the district and state commission level, they should be well equipped with the facilities and the latest technology. Because now, if we are going towards the e-filing and this e-court concept, then definitely the members should be well equipped. And the timely appointments of the members, it is the main issue, and the training of non-judicial members is more vital. The training of because this is the new act, now every member will need to go thoroughly, and he needs in part training also. Like IIPA New Delhi, which conducts the training, I feel in southern India, there should be training center at NLSIU, which is very nice institute, and I think I'm sure they will definitely provide the training to our members under the chair of under the heading department of and the chair of consumer chair, Dr. Patil. To take this act at the grassroots, I think this act to be the provisions of this act is needed to take up to the grassroots level. Who will take it? The district commission members, the NGOs, the consumer activists. It is their duty to enlighten, to tell the people about the increased jurisdiction. How can you file? How very easy, how easy the filing of the case is now. There is also need to implement the rules in its letter and spirit for the recruitment salary to attract the intellectuals to become a member. I know due to COVID, the government may delay, but it is definitely expected from the state commissions to move forward and interact with the state governments to implement for the formation of new rules, their rules and implementation of the same as soon as possible. I strongly agree with the Vice Chancellor of NLSIU, Professor Sudhir Krishnaswamy, who in his inaugural address suggested for 1 year postgraduate diploma course in consumer law and practice, which has been started at NLSIU it is headed by Dr. Ashok Patil, who heads the chair of consumer law. And I'm sure that if the members of district and state commission members are provided such training, that will certainly help to adjudicate the consumer problems, consumer litigations very efficiently, because the act is new. What we need, it is to be taught or it is to be trained in some manner, and NLSIU will play a pivotal role in this matter. The postgraduate, I know about the diploma course. It has covered before already. It was the course was already there, but it has covered in wider aspects about the product liability, misleading advertisement, mediation. Already they have covered. Also, there is a online mediation center also, where I frequently visit NLSIU, online mediation center, and it is fantastically doing, and such center should be encouraged by the government, either state or central government. So, therefore, to conclude, the total program was very nice. All the speakers, they gave their input by the heart. It is very excellent. Either you take mediation or the e-marketing and other things, everything spoke well. By that, not you also, I also got much more information about the new act, where, because I am a medical person, I will restrict only for the medical negligence and other, not restrict, I will more concentrate on medical negligence. But by the way, I have to be with the present system, and this was very good program which organized by National Law School. I thank all the organizers, Professor Patil, the Vice Chancellor of NLSIU, and all the participants whom I know. Few are from Maharashtra, Karnataka, and from South Hyderabad. I know few people. Thank all the participants who have participated. Your duty is to disseminate what you got, what you gained, and start working on the new Consumer Protection Act and adjudicate efficiently. All the best. Thank you very much, sir, for invite. Thank you.
Thank you, sir, and we'll assure you that we'll spread the awareness of a consumer welfare laws by providing more webinar, by establishing more webinars in the upcoming webinars in future. So now I request Professor Ashokar Patil to deliver vote of thanks. Over to you, sir.
Thank you, Akshay. We have planned when the act was notified on 20th, half of it, and then on 23rd, the e-commerce, on then 24th, complete legislation. Immediately we thought of planning the webinar series, because we cannot do now physical training programs. So immediately we planned and contacted all the concerned people from ministry, secretary, additional secretary, and president of National Commission, just through phone, WhatsApp. Immediately they accepted our invitation and agreed to come as a resource persons. And even other resource persons, when I contacted through phone, everybody happily accepted my invitation and came and delivered excellent presentations. So that's why this particular success of this webinar series goes to all the resource persons also. So in this valedictory session, I acknowledge our Honorable Mr. Justice R.K. Agarwal, President of National Commission, Ms. Leena Nandan, Secretary, Minister of Consumer Affairs, my Vice Chancellor Sudhir Krishna Swamy, who were there in the inaugural session. So my sincere thanks to them for coming over here and delivering excellent presentation, discussion to all the participants. Second day, Ms. Nidhi Khare, Chief Commissioner of Central Consumer Protection Authority, and Mr. Wagish, Advocate, both were presented on Central Authority. And my sincere thanks to both the resource persons. Then on third day, Pratima Narayan on e-commerce, she delivered. My sincere thanks to Pratima Narayan. Then fourth day on mediation, Shiv Kumar, Advocate Senior Mediator from Bangalore, he delivered on mediation. And always in all the sessions, technical sessions, we kept half an hour, 30 minutes for discussion, question and answer. That was more effective after presentation. So all the participants' questions are taken and discussion took place. So Shiv Kumar, I appreciate Shiv Kumar's presentation, and my sincere thanks to Shiv Kumar. And yesterday, that was on the product liability. Jaina Kotari, Senior Advocate, Supreme Court of India, and Shirish Deshpande, Advocate and Chairman of Mumbai Grak Panchayat. They presented on product liability. Excellent presentation. Everybody appreciated that. And on behalf of National Law School, my sincere thanks to Jaina Kotari and Shirish Deshpande. And today's session, my sincere thanks to Anita, who has presented on misleading advertisement, and also Honorable Dr. S.M. Kantikar, member of National Commission, who agreed to be the chief guest for valedictory address. So my sincere thanks to both of you. And last but not least, our IT department of National Law School, Vinod, Mr. Vinod and Satyanarayan, always with us whenever technical issue happens. Immediately they used to fill that particular problem, and all 6 days effectively internet connection, all the facilities they have made. Hence my sincere thanks to Vinod and Satyanarayana, and also Komla, admin of our consumer chair. And there are other people who assisted from away, Mr. Parth and Mr. Bhuneshwar, who are the professors at Christ University. Sitting there itself, they assisted managing the Facebook page, whatever questions asked in the Facebook page, that also they transferred, and attendance, all those things done, and reporting, all those things are done by Parth and Bhuneshwar. My sincere thanks to them also. And last but not least, all the 6 days, not only all the 6 days, whole month worked behind it is Akshay Yadav, who was behind all the programs, all the connectivity, everything. A one-man show, all-rounder. So my sincere thanks to Akshay Yadav, who is behind this webinar series, contacting the resource persons, sending the emails to them, getting the CV, all the things done by Akshay Yadav. My sincere thanks to Akshay Yadav also. At the end, my sincere thanks to all the participants. I got a lot of messages, emails. They are interested to participate, and they requested us to send a link. Even state commission members throughout India, district commission members and institutions, NGOs, everybody participated actively and made this particular webinar series successful. Hence, my sincere thanks to all the participants who have participated in all 6 days and made it successful. So once again, I'm thankful to all. Before I conclude the vote of thanks, I request Akshay to make some announcements.
So there is a slide announcement for the participants that the feedback link will be sent across by tomorrow evening 5 p.m. and the certificates, the time required for the certificates, it will be around 1 week time is required for circulating the certificates. Thank you so much.
Thank you, Akshay.
Yes, sir. Thank you one and all.
Thank you very much, sir. Kantikar sir, Anita. And
thank you, sir. Thank you, Akshay.
Thank you.
Thank you, sir.
We are hereby concluding the webinar series. Thank you.